Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. If you've not yet had an opportunity to review the Idaho versus Kohberger docket for the very important 4 motions in limine that the state of Idaho filed on February 21st that have just appeared on the docket today, which is the 25th of February, I cannot recommend that you do so more highly than I am right now. These motions in limine are absolutely crucial. This is where the parties before trial are asking the court to order something be kept out of the trial on grounds of prejudice, that it's irrelevant, that it would be harassing, that it would violate something. It could be testimony of lay witnesses or expert witnesses. It could be documents. It could be emails. It could be video. It could be anything that someone might otherwise seek to introduce at trial, and then the other side gets wind of it and says, no, okay, let's get this taken care of before trial, because the last thing we want to have is in front of the jury, someone introduces something that's irrelevant, that's prejudicial, that's harassing, and down the line, then we have to go through the series of objections. The jury might have to be let out, and then it might prejudice them to see the attorneys begin to argue before the judge lets them out. We're going to hit this on the head right now before trial, and that's what in limine motions are intended to do. I am going to discuss the motion in limine regarding alternative perpetrator evidence, because when I saw this on the case summary page yesterday, which was the 24th, before it actually hit the public docket, I thought to myself, wow, I wonder what the state is looking to have Mr. Kohberger be prevented from introducing at trial as it relates to some sort of evidence that points to an alternative perpetrator instead of him that might raise reasonable doubts. There's nothing specific in this motion whatsoever. I anticipated that since we just read the transcript from the January 23rd, 2025 closed and sealed hearing, where the issue of BLOOD being on a banister leading from the second to the first floor at 1122 King Road, or in a glove that was found outside of the house, maybe that's what this motion would be looking to attack, that Mr. Kohberger couldn't point to that and use that as grounds to point to, hey, it wasn't me, it was someone else, to raise reasonable doubt. This motion does nothing except explain what the legal standard is. It says here that page 1, comes now the state of Idaho and respectfully moves the court in limine, that's before trial or at the eve of trial, for an order prohibiting the defendant from offering, quote, alternative perpetrator evidence or argument without first satisfying the court that any such evidence is relevant and admissible pursuant to IRE, that's the rule of evidence 401, 402, or 403. And then in further support thereof, the state refers the court and counsel being the other side, to the case of State versus Meister. This is the Idaho Supreme Court addressing the standard for assessing the admissibility of alternative perpetrator evidence. This to me is almost like you have 2 teams that are going to play a football game, 2 professional football teams, and they want the ref to tell the other team now that the other side can't run for a touchdown unless they're running in the direction of the opposing team. Like they can't run for a touchdown running sideways or jumping up in the air and hopping onto a helicopter that might be above. They've got to run to the opposite side. That's a rule of the game that one would think you don't need to explain to the other side. Certainly if something is violated, then you raise an objection. But here to take the time and effort to file a motion in limine when there's no specific evidence that they're pointing to and no documentation where maybe they made up, just as an example, some person that doesn't exist and they've referred to this person 2, 3, 4 times during the course of the trial. That's one thing. But just to basically say, Judge, they need to if they're going to try to introduce alternative defendant, another one out there, not Mr. Kohberger who committed these crimes, they have to play according to the rules of the game. I don't understand this motion. I don't understand what Mr. Thompson, who signed it, is intending to do here without having some sort of specifics. Now contrast this with the motion in limine regarding the alibi defense. I thought that one was spot on, because there has been some filings in the past that Mr. Thompson pointed to where they pointed out that what Mr. Kohberger has filed does not comport, according to the state of Idaho, with what Idaho law says he needs to submit in order to raise the alibi defense, and that if he doesn't, then he needs to then take the stand. The state has been saying this consistently for almost 2 years now. Latah County, but to just come in out of nowhere and to say that the other side should not be able to raise evidence, point to evidence of a possible alternative defendant or another person without having some specifics of where they've done this or why you think they're going to do this, I don't understand this motion. I would love to get your thoughts on the matter. If you'd like to read it, follow the link that I have provided in the description to this presentation. Go to the Idaho cases of judicial interest. You're going to have to scroll down a while. The docket has become so large in the past 2+ years since this case has been proceeding. And take a look at this motion in limine and let me know what you think. As always, if you like our content, please like, subscribe to the channel. It would really help us grow, and I would greatly appreciate it. Until next time, this is Kathy. Thank you so much for joining us here today at the Indie Zone.